right, thank you so much. My name is Rachel Haynes. I'll be moderating today's press conference. We'll start in the room for questions, and then we will go online for anybody who has questions there. I just ask that if you're joining by Zoom to please raise your hand when the question period starts. If you are using a headset today, please make sure that you put it on the sticker in front of you to protect the hearing of our interpreters. And I will now hand it over to Anaïs Bussières McNicoll from the Canadian Civil Liberties Association.
Thank you. Good morning, and thank you for being with us today. My name is Anaïs Bussières McNicoll. I'm the Director of the Fundamental Freedoms Program at the Canadian Civil Liberties Association. The CCLA is an independent, national, non-governmental organization that was founded in 1964 with a mandate to defend and foster the civil liberties, human rights, and democratic freedoms of all people across Canada. Our work encompasses advocacy, research, and litigation related to the criminal justice system, equality rights, privacy rights, and fundamental freedoms. Key aspects of our mission include fighting for democratic accountability and against government overreach. I am with you today to share CCLA's serious concerns over the threat that misuses of the notwithstanding clause pose to the fundamental rights and freedoms of everybody in Canada. In recent years, some provincial governments have increasingly used this clause to override basic rights and freedoms and try to prevent courts from striking down horrendous rights violations as unconstitutional. This is deeply alarming, which is why we're launching today a national campaign titled Save Our Charter. Before going further, I believe a quick summary of what the notwithstanding clause is could be helpful. The Canadian Charter of Rights and Freedoms protects key rights and freedoms of everyone in Canada. These rights are essential to preserving Canada as a democratic society where we can live our lives freely. If some of our most important charter rights were playing cards, the notwithstanding clause would be the joker that beats them all. Section 33 of the Charter, commonly known as the notwithstanding clause, gives lawmakers the ability to shrug off important fundamental rights and freedoms protected under the Charter. When invoked, this clause prevents courts from striking down serious Charter violations contained in law. It is thus nothing short of a Charter override. The rights exposed to the Charter override are far from trivial. They include many of the most basic essential principles needed for in a free and democratic society. Some of these rights are ever present in daily life. They allow all people in Canada to freely speak up about issues they care about, to peacefully protest for their vision of a better world, to exercise their religion freely, and to collectively bargain for better working conditions. Other rights exposed to the Charter override are there to protect people at their most vulnerable. These rights ensure that every individual is treated equally under the law. They protect the life, liberty, and security of all people, regardless of their backgrounds or circumstances. They ensure that people in Canada are not arbitrarily detained and that they are presumed innocent until proven guilty of an offense. Since these rights and freedoms are so fundamental to all of us, one might ask why the Charter override even exists. The answer to this question is that it was a political compromise, as some governments supported the entrenchment of a national Charter of Rights, while the remaining provinces opposed entrenchment in favor of giving lawmakers the last word. Section 33 was seen as a way of solving that deadlock. Several elected officials directly involved in the 1981 negotiations on repatriation have since indicated that they never saw this clause as being meant to circumvent normal court process or to be used regularly to override the rule of law. Rather, they understood it would be used in exceptionally rare circumstances and only as a last resort for initiatives like establishing a specific program for a part of the population that might have seemed discriminatory under the Charter. La Charte canadienne des droits et libertés protège les droits et libertés clés de tout le monde au Canada. Ces droits sont essentiels pour préserver le statut du Canada en tant que société démocratique où nous pouvons vivre nos vies librement. Pourtant, si certains des droits les plus importants prévus à la Charte étaient des cartes à jouer, la clause dérogatoire serait le joker qui les surpasserait tous. L'article 33 de la Charte, communément appelé clause dérogatoire, donne aux législateurs la possibilité d'ignorer d'importants droits et libertés fondamentaux protégés par la Charte. Lorsqu'elle est invoquée, Cette clause empêche les tribunaux d'annuler des lois violant certains droits garantis à la Charte. Les droits exposés à la clause dérogatoire sont loin d'être insignifiants. Ils comprennent certains des principes les plus fondamentaux et les plus essentiels à une société libre et démocratique. Certains de ces droits sont omniprésents dans notre vie quotidienne. Ils permettent à tout le monde de s'exprimer librement sur des sujets qui leur tiennent à cœur, de manifester de manière pacifique pour leur vision d'un monde meilleur, d'exercer leur religion librement et de négocier collectivement pour obtenir de meilleures conditions de travail. D'autres droits exposés à la clause dérogatoire ont pour but de protéger les individus lorsqu'ils sont à leur plus vulnérables. Ce sont des droits qui garantissent que chacun est traité de manière égale par la loi. Ils protègent la vie, la liberté et la sécurité de tous, quels que soient leurs antécédents et leur situation personnelle. Et ils garantissent que les personnes ne sont pas détenues arbitrairement et qu'elles sont présumées innocentes jusqu'à ce que leur culpabilité soit prouvée. Puisque ces droits et libertés sont si fondamentaux pour chacun d'entre nous, certains pourraient se demander pourquoi la clause dérogatoire existe. La réponse à cette question est qu'elle résulte d'un compromis politique. En 1981, lors de l'élaboration de notre charte, certains gouvernements étaient favorables à l'établissement d'une charte nationale des droits, tandis que d'autres s'y opposaient, préférant laisser le dernier mot aux législateurs. L'article 33 fut considéré comme un moyen de sortir de cette impasse. Plusieurs élus directement impliqués dans les négociations de 1981 sur le rapatriement ont depuis indiqué qu'ils n'ont jamais considéré que cette clause dérogatoire était destinée à contourner les procédures judiciaires normales ou à être utilisée régulièrement pour passer outre à la règle de droit. Ils ont plutôt compris que cette clause serait utilisée dans des circonstances exceptionnellement rares et seulement en dernier recours, par exemple pour des initiatives telles que l'établissement d'un programme spécifique pour une partie de la population pouvant sembler discriminatoire au regard de la Charte. For 40 years, almost every province refrained from using the charter override. Alarmingly, this is no longer the case. In recent years, some provincial governments have used or attempted to use the charter override to prevent education workers from striking, ban provincial government employees from wearing religious symbols, prevent non-French speakers from receiving public services in other languages, prevent trans youths from using their chosen names and pronouns in school, and limit organizations from sharing their political views a year ahead of the elections. This trend might very well be just the beginning, with provincial and federal political leaders voicing an increasing willingness to use the charter override to deprive people of their rights. At the federal level, in May 2024, the leader of the official federal opposition party hinted that he would use the notwithstanding clause to override rights that ensure a person charged with an offense is not denied their liberty until they have their day in court and people do not face cruel and unusual punishment. In Ontario, on December 5, 2024, the Premier stated that his government is fully prepared to use the charter override to clear out encampments of unhoused people if courts were to strike down as unconstitutional upcoming laws that will attempt to address the homelessness crisis. Au Québec, en novembre 2024, le premier ministre du Québec a déclaré qu'il était prêt, si nécessaire, à utiliser la clause dérogatoire pour obliger les médecins formés dans les universités québécoises à exercer dans la province pendant un certain nombre d'années. Quelques semaines plus tard, le gouvernement a déposé un projet de loi à ce sujet qui, pour l'instant, n'invoque pas la clause dérogatoire. Toujours en novembre 2024, le Comité consultatif sur les questions constitutionnelles du Québec, au sein de la Fédération canadienne, créé à la demande du gouvernement québécois, a déposé un rapport. Une des recommandations de ce rapport indique qu'en certaines circonstances, il pourrait devenir adéquat pour la province d'utiliser la clause dérogatoire à l'égard de toutes les lois québécoises. Enfin, vendredi dernier, le 6 décembre 2024, le premier ministre du Québec a annoncé qu'il était ouvert à utiliser la clause dérogatoire afin d'interdire la prière dans des lieux publics tels que les rues et les parcs. This needs to stop. If governments can use the charter override without consequence, they won't hesitate to do so time and time again. If our rights and freedom can so easily be overridden, our charter is in danger. This should concern everyone. Governments could one day decide to use the charter override to ban speech that is critical of people in power, or to imprison people without giving them due process and a fair trial. The CCLA is already fighting misuses of the charter override through important court cases, but more needs to be done. Through our new Save Our Charter campaign, we are calling on the Parliament and each provincial legislature to enact laws explicitly limiting their own use of the Charter override within certain parameters. At a minimum, these parameters should include 3 points. First, there should be no preemptive use of the Charter override. This means that lawmakers should not use the notwithstanding clause until after receiving a final decision from a court on the constitutionality of a law. In other words, lawmakers should aim to enact laws that comply with the Charter and should let courts review the constitutionality of these laws. The public deserves to know if governments are infringing on their fundamental rights and freedoms. Second, a supermajority should be required to invoke the Charter override. Our charter rights and freedom are too important to allow the Charter override to happen by a simple majority vote. A supermajority would echo the severe consequences that flow from overriding charter rights. Third, egregious rights violations should not be allowed to stand. This means that even if the charter override has been used, courts could still review a law's purpose. Where that purpose is incompatible with our constitutional structure, the courts should be explicitly allowed to strike down the law. This would be the case when a law directly attacks a core fundamental right, freedom, or legal protection that existed well before the Charter was enacted. Notre campagne Sauvons notre charte poursuit aussi un autre objectif, soit celui d'alerter le public et de l'informer sur les dangers de l'usage abusif de la clause dérogatoire. Nous invitons la presse et le public à consulter notre page bilingue dédiée à notre campagne sur notre site web, y compris notre pétition qui exhorte les gouvernements provinciaux et fédéraux à ne pas utiliser la clause dérogatoire pour permettre des violations flagrantes de nos droits et libertés. For more than 40 years, the Canadian Charter of Rights and Freedoms has been defending all of us by protecting our fundamental rights and freedoms. It is now our turn to defend our Charter from the recurrent use of the notwithstanding clause to override basic rights and freedoms. Respect for human rights and civil liberties is a bedrock of democracy. No democratic society can thrive without robust protection of these rights. The recent, rampant, and growing use of the Charter override has put important charter rights and our society as a whole under threat. Now is the time to act, to save our Charter. Thank you for your time.
All right, thank you so much. We'll go to the Q&A now. We'll start in the room. If you are on the Zoom meeting right now and you do have a question, please raise your hand at this time. Thank you. And we'll start with Dale Smith in the room with one question and one follow-up.
I guess my first question is, what do you think has caused the political prohibition to not use this clause to weaken, particularly over the last half decade, and for ostensibly democratic governments in this country to start eroding guardrails like this?
Well, I think it's a recent use that is growing. It's rampant. It's insidious. I think when a use of the notwithstanding clause only focuses on one part of the population, it's easy for the rest of the population who's very busy, who has things to do, and not to be concerned with this specific use and to trust their governments. We're here today to say that this should concern everybody and that this is a very dangerous trend.
Over in the Senate, there's been discussion amongst senators around future use of the notwithstanding clause on a federal level and whether this would be something that they might use their veto power to strike down in cases, for example, where it's been used preemptively. And I'm wondering if you have a thought or an opinion on those kinds of discussions around that use of the Senate's veto power.
Well, our thought is that it's very important for everybody to feel very concerned about this increased use of the notwithstanding clause, and for all of us to be exploring options as to the best way to make sure that this doesn't deprive people from their rights and freedoms. We believe that the suggestions we're making today and the call we're making on governments to listen to us, meet with us, and explicitly limit the use of the notwithstanding clause within 3 parameters is the right way to go. But we're, of course, open to other discussions on that topic.
Thank you. Helen, do you have a question in the room? Helen? No question? Okay, perfect. We'll go to Stuart Benson from the Hill Times over Zoom.
Hi there. Sorry, I had a bit of sound issues, so sorry if you covered this and I missed it. But just with your for the recommendations or parameters for when the notwithstanding clause could be used, I can imagine a bit of a sort of a, I don't know if catch-22 is the kind of issue, but the problem that you're highlighting is that increasingly premiers are using the notwithstanding clause to override the charter. So how would you, I guess, get those same premiers to comply with these recommendations? I mean, whether it's legislation or the charter, if they already have the notwithstanding. So I just, how would you imagine, I guess, carrot or stick approach to get these recommendations or parameters to stick?
Absolutely. And I mean, we're very aware of this situation, of this concern. The suggestion that we're making today is one that is pragmatic, more pragmatic than suggesting to reopen the Constitution and amend it, for instance. That's also why there are two parts to our campaign. The first one being that we are making this call on governments, but we're also trying to raise public awareness. And I think the answer really is going to have to come from the public, who has to feel worried about this growing news and the threat that it poses to their rights. And also there is this hope that if some provincial governments are open to the suggestion and adopt our suggestions, that it will put pressure on other governments to explain to the voting public why they are not valuing rights and freedoms in the same way as other provincial governments or the federal government are.
Do you have a follow-up, Stuart?
Sorry, no, that was my only question.
Thank you. If you are still online and have a question, please raise your hand again. If not, do you have any, if you have more time for some more questions in the room, Dale, do you have another question?
I guess if you can just talk about some of the examples we've seen in the last year or two, and both, I guess, the insidious nature, but also how these kinds of things play into things, for example, like scapegoating particular communities and so on. If you can just explain how those dangers manifest themselves.
Mm-hmm. Thank you for the question. I mean, the example we heard of last Friday, which is not a concrete use of the notwithstanding clause, but certainly the Premier of Quebec mentioned that he was thinking of using the notwithstanding clause to prohibit prayers in public spaces, such as streets and parks. I mean, this is a very, very dangerous trend to be following. This would be, if he goes forward with this initiative, this would be a direct violation of the freedom of religion and freedom of expression as well. And we have to keep in mind the fact that this would be a start of shrinking our civic space, because parks and streets are places where people should be able to gather peacefully, of course, and not by blocking circulation, of course, but gather peacefully to express their opinions, but also their faith, and exercise their charter-protected rights. So this is an example of a deeply concerning allusion to the potential use of the notwithstanding clause.
Just a little more about things like how the attack on, for example, the rights of trans youth have been essentially been whitewashed in certain pundit spheres, where people excuse that as, oh, that has supermajority support in the public, so therefore this should be acceptable. That kind of an argument.
Thank you for the question. Our position is definitely that governments should be enacting laws that comply with the Charter, and they should be prepared to defend the constitutionality of their laws in front of courts. And that's not to say that rights and freedoms are absolute, but courts are in the position to decide whether or not there is a violation of our rights and whether or not that violation is reasonable and justifiable in a free and democratic society. So to take the example of Saskatchewan, well, CCLA's position is that clearly the law that was adopted imposes irreparable harm on the most vulnerable students, young people who may not be in a position to get support from their families, and that the law violates Section 7, the right to life, liberty, and security of the person, as well as equality rights of trans and gender diverse students.
Just actually go online, and then if we have time after that. So we'll just go to Catherine de Klerk from the Trillium over Zoom.
Hi, thanks for taking my question. in Ontario, there's been a bit of switch in terms of the proactive use of the notwithstanding clause to clear encampments, but it's been said that if the courts basically interfere with the goal, the notwithstanding clause will be used. So in terms of your recommendations, would that make sense? Is it the correct use of the notwithstanding clause? Would that still be considered preemptive use?
So it wouldn't be considered preemptive use if the clause is used after courts have declared that upcoming laws are unconstitutional. But we do have a very big problem with this announcement of the government that they are prepared to use the notwithstanding clause to override court decisions and circumvent those decisions because courts have already recognized that unhoused people have a right to shelter, and if there is no safe shelter accessible and housing accessible, well, they have a right to be in encampments. So the burden should really be on the shoulders of the government to adopt policies and laws that are charter compliant and that address the very real and pressing crisis of homelessness in Ontario and other provinces. So instead of using the notwithstanding clause, governments of all levels need to work together and find solutions to this very pressing crisis, but in a way that takes into consideration and respects charter protected rights.
Catherine,
In terms of, oh, sorry.
No, I was just going to say, if you have a follow-up, you can go.
Thank you. In terms of the Save the Charter campaign itself, so you have this news conference. What else does it involve? And so to convince the public that this is not the right thing, or to convince premiers or politicians not to use it.
Sorry, Catherine, we couldn't really hear your question there. Are you able to say it again? And there just seemed to be a bit muffled.
Yes. I just wanted to know what's involved in the Save the Charter news conference. Are you going to be using, or you guys are trying to convince premiers?
I'm sorry, Catherine. We really can't make out what you're saying. So I wonder if you're able to switch to a different headset, or if you are using headphones, maybe you can sort that out. And maybe in the meantime, we'll just go to one other question in the room and I'll come back to you.
The other thing we've seen, along with use of the notwithstanding clause in places like Saskatchewan and is talked about in Ontario, is governments also preemptively shielding themselves from litigation, from the harms that they have basically allowed through use of the notwithstanding clause. And I'm just wondering if you can also make a comment on this particular phenomenon of also this notion of governments shielding themselves from liability for use of the notwithstanding clause and the harms that it will cause.
Absolutely. So there's an interesting aspect to the notwithstanding clause, which is that it has to be reenacted every 5 years. And the thinking behind that was that within 5 years there would be an election, of course, so that the population would get to vote and decide whether or not they agreed with the use of the clause. The issue is if you use the clause preemptively, the population hasn't been informed by courts of whether or not there is a rights infringement and how severe it is. So that's why we have a very big issue with the preemptive use of the clause, because how can the voting public make an informed, enlightened decision as to whether or not they agree that the charter override is a valid use of government resources or not?
Thank you. And Catherine, we're going to come back to you and see if we're able to hear you again.
Can you hear me okay?
A bit better, so we'll see how the rest of your question goes.
Okay. In terms of the campaign itself, aside from this news conference, what else is the CCLA doing to, try and drive home this point and convince premiers, politicians to not use the notwithstanding clause in this way?
Mm-hmm. Thank you for the question. So what we did is last week we sent a letter to each and every prime minister, federal prime minister, and provincial premiers, calling on them to explicitly limit the use of the notwithstanding clause and seeking the opportunity to meet with their teams to discuss this very urgent problem. So we are certainly hoping that we will have the opportunity of meeting with these people and these government elected officials. And we'll also, of course, maintain the pressure. So there is, we have a web page that is live, that is that aims to inform the public about the dangers of misuses of the notwithstanding clause. And there is a petition on our website that we invite the public to go and sign if they agree with us that their governments should not be using the notwithstanding clause to override basic human rights.
All right. Thank you. We will end the press conference there. Thank you so much for your time.
Thank you.